Hello and welcome back to the lecture series for the preparation of CLAT examination. In this particular lecture series, we are discussing about the legal studies portion of your CLAT syllabus. And throughout this series, we have discussed a lot more legislations. We have discussed Indian Penal Code. We have discussed Code of Criminal Procedures. We have discussed about the law of contract. We have discussed about the Indian Penal Codes. And apart from that, we have discussed contract also, and we have discussed law of torts also. So, in our previous video sections, we were discussing about the Constitution of India, because it is going to be an enormous portion when you talk about CLAT examination. In this particular lecture, we are going to discuss about the directive principles of state policy. On our earlier video, we have discussed about the fundamental rights. We have in detail studied about what exactly is state, what exactly is Article 13, which is talking about law inconsistent derogation with fundamental rights will be considered as null and void. We have discussed Article 14, which talks about equality. Then we have talked about 15, which talks about discrimination on the basis of caste, creed, religion, and place of birth. And then we have talked about promotion and employment, and under Article 16. Then we discussed about 17 and 18, which talks about untouchability and abolition of titles. Then we have studied about Article 19 also, which we have studied about the fundamental freedoms that has been given to the citizens. After that, we have studied Article 20, which talks about freedom from arrest and detention. And then we have studied Article 21, which talks about right to life. Then we have studied about Article 22 also, which is talking about preventive detention and punitive detention. Apart from that, we have discussed about right to religion, which starts from Article 25 to 28. We have discussed about right against exploitation, that is in 23 to 24. And opposed that, we have discussed about Article 29-30, which talks about reservation for backward classes and cultural educational rights. And then post that, we have discussed about right to constitutional remedies that has been mentioned in Article 32 of the Constitution. We have discussed about the various writs that are present to the citizens, and we have discussed about habeas corpus, mandamus, quo warranto, certiorari, and mandamus. Mandamus, habeas corpus, certiorari, prohibition, and quo warranto. So we have discussed all these 5 writs. We have talked about the relation between the writs that can be given by the Supreme Court and how is it different from the High Court. The scope of High Court is perhaps higher than the scope of the Supreme Court. And apart from that, we have discussed about various cases which gets attracted whenever we are talking about Article 14, 19, 21. We have talked about A.K. Gopalan case, we have talked about Maneka Gandhi case, we have talked about Olga Tellis case, we have discussed K.S. Puttuswamy case, we have discussed Nalsar case, a lot of things that we have discussed so far. And I would like to tell you that in these particular lecture series, we are only focusing over the most important portions that are going to be there in your CLAT examination. So we are not teaching you anything which is going to not be included in your paper. We are strictly sticking to the syllabus that one has to go through when we are going for a CLAT examination. And in the same way, in today's lecture series, we are going to discuss perhaps the only important portions of the directive principles of state policy, which we need to remember and recall whenever we are talking about CLAT examination as the main agenda. And all the competitive examinations obviously have some sort of similarity. So whenever, even if you're preparing for other examinations which resonate almost as same pattern as that of CLAT examination, then these videos are going to be very much helpful for you, because they will not only help you in understanding what are the different parts and what are the different provisions that has been there under the Constitution of India. It will also nourish your knowledge in such a manner that you will be able to step aside and come out from the league of the general public, and you will be able to know in a precise manner what exactly are your rights and what exactly are your obligations. So As in the previous video, now we have explained it to you that what exactly is fundamental right, and we have discussed that fundamental rights are given to the citizens. So when we talk about directive principles of state policy, what we need to understand is that whenever you're talking about the directive principle of state policy, that is D. Yes, it's not working. I saw. Yeah, it's working. When we talk about directive principles of state policy, what we need to remember is the directive principles of state policy are under part 4 of the constitution. That is very important because there are sometimes questions being asked in direct format that you will get match the followings, and in the match the following there will be part 1, 2, 3, 4, and in the present you will have citizenship. You will be asked fundamental rights. You'll have mention of directive principles of state policy, and then will be talking about territory, and then you'll be asked that under which part which thing is being mentioned. So it perhaps becomes important for you to remember the parts also. Everything is important when you talk about preparation of competitive examination, but the things that are perhaps being asked on repeated basis becomes important topics, and those important topics plays a vital role, that whenever there are questions that will be put forward, these areas will be focused first, and that is why how we segregate these are the important sections and these are non-important sections. There can be, when you talk about syllabus, the questions can be asked from any portion of the syllabus. But practically, it is understood that it becomes almost impossible, and it will take a hell lot of opportunities to be given and provided for the students, and continuous lectures and consistent approach will have to be there in order to complete the whole syllabus, and then it becomes practically impossible for any of the candidate to retain each and everything that whatsoever has been mentioned in the syllabus. So, and in-depth analysis of the law is not expected from a CLAT aspirants. So only the important portions becomes very relevant, and that is why it is always um, advised that we go through the strict patterns that is being followed under the CLAT examination. So parts you have to remember, very important. So let's come back and discuss what exactly is direct principles of state policy. So when we talk about directive principles of state policy, first we need to understand that directive principles of state policy is nothing but it is just a directive. A directive that has been given to the state government, which they need to follow in order to make laws. That whenever the government are going to they are going to frame laws, they have to make sure that they are abiding and adhering to these directives which has been provided. So they have to be on that particular, they have to follow these directives that has been provided in the part 4 of the constitution, which talks about directive principles of state policy. So when we talk about directive principles of state policy, the first thing that you need to remember is that these principles are in the nature of directives to the government to implement them from establishing what? Social, economic and democracy and social and economic democracy under the country. So in order to ensure social and economic democracy, we follow directive principles of state policy. This was given as a novel feature of the constitution by important laureate B.R. Ambedkar. And this has always sometimes been asked in your paper that who among the following has mentioned directive principles of state policy as a novel feature of the constitution. So these are the important things that you need to remember, and perhaps the most important thing that we need to remember about directive principles of state policy are that they are non-justifiable in nature. What does that mean? When we say non-justifiable in nature, it means that they cannot be enforced in the court of law. And why it has been so that we have not uh, considered directive principles of state policy that they cannot be enforced in the court of law, because they are just a directive, first thing. And second thing, it is in order to ensure social and economic democracy. And social and economic democracy always depends on the economic conditions of the country. So once the economic conditions of the company are such that they can even uh, no, they can even think of enforcing directive principle of state policy. Perhaps in future we might find that directive principle of state policy may also becomes enforceable. But as of now, it is considered that it should be only considered as a directive. They are not legally enforceable by the court of law. Its obedience or implementation cannot be secured through judicial proceeding, but still these are the fundamentals in the governance of the country. Okay, so these are the things that we have already studied. So here from this particular portion, part 4 of the Constitution, you will find mention of the directive principles of state policy. And start from Article 36 and it goes to Article 51. 51A is talking about the fundamental duties. That is something that is under Part 4A of the Constitution that we are going to study later on. But let's understand what are the directive principles of state policy and what does that means. The first and the foremost article which talks about directive principle of state policy is the definition, and it is providing the definition of the state, not the directive principles of state policy, but the state. And state, it says that in this part, unless the context otherwise requires, the state has the same meaning as that of part 3. It means that whatsoever that has been, we have studied earlier in, while we were discussing part 3 of the Constitution, the same definition which has been mentioned under Article 12, the same definition is for Article 36 also when you talk about directive principles of same state policy. So directive principles of state policy and fundamental rights have the same definition of state when we are referring to Article 12 for fundamental rights and Article 36 for directive principles of state policy. So the same meaning which the parliament and everything has been included under the directive principles of state policy. The one thing that you need to remember about the directive principles of state policy, it has been derived from the Irish Constitution. It is an important portion because we know that our Constitution has been created by taking into consideration many constitutions, and after referring to various constitutions, we came out with a unique and perhaps the most sought after constitution, that is India Constitution, that is Indian Constitution. And in that particular part 4 of the Indian Constitution, we find reference to Article 36, that is directive principles of state policy. And when we talk about directive principles of state policy, there is one more thing that we need to remember, and that is the directive principles of state policy can further be classified into 3 major groups. The one being socialistic principles. Socialistic principles. This is one. The second being Gandhian principles. Gandhian principles. And the third being liberal intellectual principles. These are the 3 principles that we have to take into consideration when in order to retain that what exactly is directive principles of state policy. Under the socialistic principle, if we further classify it, that which are the different articles that you'll find mentioned under socialistic principles, then these articles would be Article 38, 39, 39A, 41, 42, 43, 43A, and 47. So these are the articles which you will find mentioned in the socialistic principles. Then the Gandhian principles, you will find mention of 40, 40, 43, 43B, 46, 47, and 48. And under the liberal and in the liberal intellectual, you will find mention of Article 44, 45, 48, 49, 50, 51. Now, how will you be able to tackle a question which will be in regards to these principles? Obviously, they were not going to ask you what is socialistic principles, Gandhian principles, and liberal principles. But there can be a paragraph where which it will be mentioned that the direct principle of state policy has been on the different principles, be it socialistic principles, Gandhian principles, and liberal intellectual principles. Classify which among these articles has been considered under the socialistic principles or directive principles of state policy, and then they will give you different articles. They will give you Article 38, they will give you Article 43, they will give you Article 45, and they will ask you, maybe Article 50 would also be there, and then they will ask you under which principles these three articles falls. So you have to be very specific that you need to retain it and under which article, which principle is being followed. And this is how you make sure that whatsoever is going to be there in your examination, you cover up each and every portion. So these are things that you need to remember. And so Article 36 is talking about the definition. Article 36, we have Article 36, we are talking about the definition of the state. Under the definition of the state, we have studied under Article 12 that state includes the executives, legislatures of union and state. I'm just shortening it down for your better understanding. And all local and other authorities. All local and other authorities. Then we have studied the different case laws when we're talking about the other authorities. I'm not going to repeat it again. Then this is the major portion which talks about Article 36. Article 37, which talks about application of principles contained in this part. It is said that it shall not be enforceable, that we have already studied, but the principle therein lay down on nevertheless fundamental in the governance of the country and shall be the duty of the state to apply these principles in making the laws. So this is what I have just informed you, that the application of these principles in this part shall only be a directive for the better governance of the country, for the state to apply these principles while they are making the laws. So this is an important portion that you need to remember. Article 38 is talking about welfare of the people. This is the main crux of Article 38, and that is what you need to remember when you're talking about directive principle of state policy, that whatever we are going to make should be for the welfare of the country. Then we have Article 39, that principle that needs to be followed, that what are the principles that whenever the laws are being formed by the government, the first thing that they need to remember is that there should be an adequate means of livelihood for the citizens. It includes that it is the citizens, men and women equally. Okay, the citizens has been further classified under men and women, that they should be equally, that the citizens, men and women equally, the right to an adequate means of livelihood should be there. When you talk about adequate means of livelihood, it means that the citizens, whether it be a man or woman, should be given equal adequate means of livelihood. It can be employment also, it can be food and shelter also, everything. Okay, then the ownership and the control of the material resources of the community are to be distributed as to best to serve the common good. So it should not be like that a state, Uttar Pradesh, is getting majority resources and Bihar has less resource. I'm just giving you a citing example. It is not true to the best of my knowledge, but just to make you acquainted of this particular thing, that ownership and control of the material and resources should be equally distributed. Okay, and then the C is talking about the operation of the economic system does not result in the concentration of wealth and production of common detriment. So there shouldn't be concentration of wealth, and this on this basis only our income tax slab has been decided that it will be 15, 20, 25%, etc. Okay. Now, equal pay for equal work, that is a very important article. You need to remember that equal pay for equal work for both men and women is under Article 39. That the health and strength of the workers, men and women, and the tender age of children are not abused, and that the citizens are not forced by economic necessity to enter avocations unsuited to their age or strength. So it has to be in such a way. Article 39E becomes a very important article whenever we are talking about the policies that the government needs to formulate, that the policies should be such that the citizens are not forced by what? By economic necessities. That because of financial constraint, necessity to enter avocations areas, job settlements, unsuited to their age or strength. Unsuited to their age or strength, if somebody is working just because of their financial situations, then it will be considered as a defeat of the government. Because ultimately, if the government is not able to follow the directive principles of state policy, and they are unable to maintain the status quo of all the citizens not being forced to, because of the economic necessity, enter avocations unsuited to their strength, then obviously the policies which has to be followed has not been followed by the government, and that is perhaps the reason it has been there. Now, Article 39A plays a very important role because it is talking about equal justice and free legal aid. Free legal aid means that when this article was article was instituted, it made sure that to secure the justice, the operation of legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid. So the government should make rules in such a manner that there should be free legal aid that should be provided to every citizens. And that is why you will find mention of National Legal Service Authority, NALSA, State Legal Service Authority at every in every state. And then apart from that, you have District Legal Service Authority at every district in order to ensure that equal justice and free legal aid be provided to every citizens. Okay, and this particularly Article 39 has been brought about by the amendment. 39A has been brought about by an amendment of 42nd Amendment 1976. And you need to remember the date of this particular amendment also, because since it is a very important amendment, it is also considered as the mini constitution of the Indian Constitution. The reason being, this amendment has brought about a lot of changes under the Constitution. A lot of amendments has been brought and becomes a very important amendment to study. This has brought Article 39A, which talks about equal justice and free legal aid. Now, when we talk about organization of village panchayat, you need to understand that what exactly is village panchayat. That is more than sufficient, and that, as you mentioned, Article 40. Then we have the right to work, to education, and to public assistance in certain cases. Here we need to remember that within the limits of the economic capacity and development, make effective provisions for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. So since it cannot be enforced, directive principles of state policy cannot be enforced. It is because of the limitations of the economic capacity. If the economic capacity is stronger, then the state shall. Okay, it is mentioned shall. It means that it is a duty of the state that state shall, within the limits of its economic capacity. So whatsoever limit they have, whether if they have for the infrastructure development and for everything they have let's assume 1 crore and they're not spending over it, then they are defying Article 41, which talks about right to work, to education, and to public assistance in certain cases. And it is the duty of the state that within its economic capacity, they should develop make effective provision for securing right to work, to education, and public assistance in case of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. Okay, so this is, you need to remember. Now, Article 42, very important one, which talks about maternity leave. Certain times you will be asked a question under which article you will find mention of maternity leave. So this is Article 42. It says that state shall make provisions for securing just and humane conditions of work and for maternity relief. Okay. Now, living wages, etc. for workers. Workers, to ensure that it is basically talking about protection of workers. For the protection of workers, we have incorporated Article 43 of the Constitution, which says that the state shall endeavor to secure what? By suitable legislations. By suitable legislation, what does it mean? It means by making laws or economic organization or in any other way to all workers, agricultural, industrial, or otherwise, work a living wage, condition of work, and what else? Ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities. And in particular, the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. So cottage industries is a focus which has been made sure by Article 43. And it is something that you need to remember also, that promotion of cottage industries. The promotion of cottage industries has been mentioned under which provisions of the directive principles of state policy? Under the directive principles of state policy. So you will find it under Article 43 when you're talking about the condition of workers. Now, Article 43A. Now, again, A has been mentioned. It means that it has been brought about by an amendment. Which amendment is that? That is against 42nd Amendment, which has brought about this particular article. What does that say? It says that the state participation of work in management. So, the workers whomsoever are going to be managed by any employer, they have to create a management system. And the workers who are going to be managed by this management system, the participation of the workers should also be there. The state shall take steps by suitable legislation or in other way to secure the participation of worker in the management of the undertaking, establishment, and other organization engaged in any industry. So this is how the participation of workers are there. But when you talk about Article 43, it becomes a very important portion, because when you talk about Article 43B, it is even considered above Article 14 and Article 19. And this is a question that was asked under the PCSJ examination, that is for the judicial examination, that which article precedes in importance Article 14 and Article 19. It was Article 43B. Although directive principles of state policy are considered to be, they are considered to be of the same value when you compare it with the fundamental rights, but there is a difference. The difference is that we need to understand here is the directive principle of state policy is non-justifiable. Justifiable. But fundamental rights, justifiable. But fundamental rights are justifiable. Means we can get them enforced under the court. But it was said under the case of Maneka Gandhi that directive principles, I'm so sorry, it was not Maneka Gandhi case. It was Minerva Mills case. Minerva Mills case. Okay, I suppose it was of 1992. I'm not sure about the date, but you can just recall the dates. But Minerva Mill's case said the directive principles of state policy and fundamental rights are to be constructed harmoniously. Because there was a lot of confusion that which is more important, whether fundamental rights are important or directive principles of state important. But it was under the case of Minerva Mills, it was clearly mentioned that both the directive principles of state policy and the fundamental rights are equally important, and they have to be constructed harmoniously. They should be considered as twin sisters who have almost the same powers, but there is a very thin gap, and that gap is that fundamental rights are justifiable and directive principles of state policies are just directives and are not justifiable. Under 43rd Amendment, 43B article, the importance of cooperative societies has been mentioned. Cooperative societies, the state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative society. And this has been brought about by the 97th Amendment of the Constitution. And from here, you will find mentions of the RWA in the society where which you are living. The Resident Welfare Association is nothing but uh, um, a portray of what Article 43B has suggested, that there should be a democratic, autonomous functioning and of democratic control of professional management, a cooperative society for what? In order to promote voluntary formation of cooperative societies who can work forward to resolve the disputes of petty things, which obviously is a need for the citizens, for both men and women. And that is why the cooperative society has been brought about under the Constitution of India. Then you have Uniform Civil Code. That is something that you have already known, that the state shall endeavor to secure for all the citizens a uniform civil code throughout the territory of India. But obviously, if I'll tell you in the practical basis of it, it is almost impossible, because every religion has a different perception which cannot be brought about in the same perspective. So that is why it is something that obviously the state shall endeavor. They will try to have a secular system, and they don't give importance to one particular system. But that's actually not possible as of now. Then we move forward for Article 45. Now you see to it that before this 45th, before the 86th Amendment, before the 86th Amendment, the age was not mentioned 6 years, it was mentioned rather 14 years. Okay. And I just told you that by bringing about the amendments in the Constitution, we can even enforce the directive principles of state policy. So what happened under 86th Amendment, that the age for compulsory education by virtue of Article 21A were given to children of the age up to 14 years, lesser than or equals to 14 years. So whomsoever has attained the age of 14, till the age of 14, the government shall endeavor that education to be provided, to compulsory education to be provided to the children between the age of 6 to 14. Between the age to 6 to 14. So now, starting from 16 till the age of 14, the government, it is now the fundamental right. So it has been considered justifiable. So if somebody is not able to get compulsory education within this span of 6 to 14 years, they can go to the court and get it enforced. But when we talk about this age group below the age of 6 to below the age of 6 years, it's starting from 0 to 6 years, it is now not the discretion but rather only a direction that has been given to the state government, to the state, that the government shall endeavor to provide education up to the age of 6 years, and above 6 till 14 it is compulsory. So now you see that earlier this was 14 years, so it was only a discretion of the government to decide whether they can provide education, whether they will be able to provide education up till the age of 14 years to the students. But now it has been made compulsory by bringing about a change by the 86th Amendment and by incorporating Article 21A, that up till the age of 14, starting from 6 to 14 years, the student will get compulsory education. And up till the age of 6 years, it is the directive that the state shall endeavor to provide early education and childhood care for all the children until they complete the age of 6 years. So this is how amendment has brought about so many changes. You need to remember the date here also. It is on 2000, in the year 2002, when Article 21A was included. Now it is talking about the promotion of education and economic interests of scheduled castes and scheduled tribes. This is under Article 46. Perhaps not a very important article, but there are certain amendments that was brought about under by this article that you need to remember. The 65th Amendment, 65th Amendment brought about SC and ST Commission. This was known as NCSC and ST, Commission for Scheduled Caste and Scheduled Tribe, National Commission for Scheduled Caste and Scheduled Tribe. And then by the 89th Amendment. So these are the important amendments that I'm discussing, and why I'm discussing it with the relevant articles, because this is how you make the connection. So whenever you're going to study, you will be able to recall that by the 65th Amendment, it is related to 46th article. And when you'll study 46th article, you will be able to recall that is related to Scheduled Caste and Scheduled Tribe. So whenever there will be an article which is going to be discussed in relation to Scheduled Caste and Scheduled Tribe, you will be able to figure out that it can be 65th Amendment also, because under the 65th Amendment we have talked about the National Commission for the Scheduled Caste and Scheduled Tribe, and under the 89th Amendment it was the bifurcation the commissions into two parts. Now we have one which is known as National Commission for Scheduled Caste, and another is National Commission for Scheduled Tribe. So there was a bifurcation that was done by the 89th Amendment, and both the commissions ensures that promotion and special care, the educational and the economic interest of the weaker sections of the people, and in particular the scheduled caste and the scheduled tribes, and shall protect them from social injustice, all form of exploitation. When you talk about scheduled caste and scheduled tribe, it is something that has been mentioned under the different schedules, which will be considered as scheduled caste and which will be considered as scheduled tribe. Okay. Now it is Article 47 is talking about standard of living and improve health. That is just a superficial article that you need to remember. There is nothing much that is going to be asked. Yes, intoxication drinks and of drugs which are injurious to health. This is something consumption except for medical purposes of intoxicating drugs and drugs. This is why you will find advisory of not smoking whenever you go and watch televisions. Then we have talking about organization of agriculture and animal husbandry. So we know that India is an agrarian form of democracy, and we are dependent a lot on agriculture for our growth and infrastructure development. So that is why the state shall endeavor, in order to maintain that agricultural benefits, organize agriculture and animal industry on modern and scientific lines. Okay, so we have to develop modern scientific lines by which we can progress in agriculture and animal husbandry also. Now 48th A Amendment, which has brought the safeguarding of the forest and the wildlife. That is also very important. Again, it has been brought about by the 42nd Amendment only. So this is something that you need to remember. 49 is talking about the protection of monuments and places and objects of national importance. Taj Mahal, you must have heard that Taj Trapezium case. Taj Mahal has from white, it is getting converted to due to corrosion of acids. The marble is converting in yellow in color. The reason is the heavy flow of industrial waste in the river Yamuna, which causes acid rain in certain seasons of the year. Oh, and whenever these rain hits Taj Mahal, it gets a chemical reaction because of which the Taj Mahal is getting a yellow color, which was earlier not present. So in order to protect these type of monuments, Article 49 giving a directive to the state that it shall be obligation of the state to protect every monument or place or object of artistic or historic interest. Okay. Now, separation of judiciary from executive, you need to remember that whenever we are talking about judiciary and executives, we have to have a clear difference and separation between the two, because if these two are combined together, then it means that the person who is going to be the judge is the person who is going to enforce the things, and it will obviously be a tyrannical rule where which the citizens might get in citizens might get exploited, and that is why it is the duty of the state government to maintain a difference and separation between the judiciary from the executive, and that is what is known as separations of power. They helps in a check and balance of all the forms of all the parts of the government, one being the uh, executive, second being the legislature, and the third being the judiciary. So all these three parts, in order to safeguard that these three parts are not uh, overlapping their jurisdictions and authorities, there should be a systems of checks and balance, and by separation of power, we are maintaining that thing. Then promotion of international peace and security. So international peace and security has been talked about under Article 51. Maintain just and honorable relation with the nation. This is our main goal. So with this, we have completed the directive principles of state policy, all the relevant articles. Here we have also studied about the directive principles of state policy and the relation between directive principles of state policy and fundamental rights. There are some important cases that I would like you to remember. The first case is Champaran Dorai Rajan case that was of 1951, which said that Article 29 2 should be read along with Article 46, and this has been brought about by First Amendment. Then First Amendment. Then the second case that you need to remember is In Re Kerala Education Bill, which talks about the compulsory education, and it is also related to directive principles of state policy. Then you have the Golaknath case. Golaknath case is a case whether the preamble has been considered as the integral part of the constitution or not has been mentioned, and it has challenged the 24th and the 25th amendment that was brought about by the government, which talks about 25th article talks about 31C, which is related to article 14, 19, and 31. So 39 was taken out by the 25th Amendment. And then the important case is Keshavanand Bharti case. Keshavanand Bharti case. But perhaps the most important case when you talk about the directive principles of state policy and its relation with the fundamental rights, then you need to recall that we have just studied the minimum mills case, which talks about that whenever we have to take into consideration directive principles of state policy and the fundamental rights, it should be in cooperation and in harmonious construction with each other. So with this, we have completed the majority of the portions which is in relation to the directive principles of state policy and fundamental rights. With this, we have completed part 4 of the Constitution. Part 5 of the Constitution, which talks about the fundamental duties, it is something that is self-explanatory. I would request you all to go through all the important fundamental duty that is being there, especially K portion, which has also been included by the 86th Amendment. So this is something that you need to recall. And with this, we have completed part 4. Now we will be discussing about we will be discussing about the executives and executives, and we'll be discussing about part 5 from our next video onwards. So with this, I would like to thank you all for being present in this lecture series. In the upcoming videos, we will be moving forward with the executives, and then we'll be completing the union portion. Post completion of that, we will be discussing about the emergency provision and the amendment provisions of the constitutions. With that, we will be completing our important provisions of the constitutions. Then I will be showing you an overficial look of the whole constitutions, what are the important parts and what are the important schedules also. Because schedule is something that will only be understood by you guys when you will study the constitution in full. But there are certain provisions and certain things that needs to be remembered by a layman. As I just informed you that whenever we are talking about the CLAT examination, it has been specifically mentioned in your CLAT consortium syllabus that a layman should be able to acknowledge those principles only are going to be there in your question paper. So that is why it becomes very important that constitution should be thoroughly understood, because majority of the questions that we will be finding mentioned in your question paper will be from the constitution itself. With this, I would like to thank you all for being present in this lecture series, and we will be continuing with part 5 and the remaining portion of the constitution in our next video. Till then, thank you so much guys. Bye bye, take care.